Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, I am going to tell you a case law decided by Honorable High Court of Allahabad, very famous High Court, Allahabad High Court judgment on a murder case, wherein if the motive is weak, if the motive is not established, if the testimony of the witnesses is not satisfactory, and if the confession lacks credibility, then the result is case will be acquitted. This is what is stated by Allahabad High Court, two judges bench, Justice Siddharth Verma and Vinod Divakar, in the case of Rajesh and others versus State. Simple. Rajesh versus State and others. Criminal Appeal number 1620 by 1982, decided on 31/5/2024. సో బేసిక్గా ఈ కేసు జరిగింది ఎప్పుడు తెలుసా అండి? 2008 సుప్రీంకోర్టులో 2024లో, అంటే 14 ఏళ్ల తర్వాత డెసిషన్ వచ్చింది. వీళ్ళకి లైఫ్ ఇంప్రిజన్ పడింది. మొత్తానికి ఎక్విట్లో బయటకు వచ్చాడు 16 ఏళ్ళ తర్వాత అనుకుంటా, కరెక్ట్, రైట్. Where the court bench held that when circumstantial evidence is not plugging the loopholes, when the motive is not well established, definitely accused definitely gets the benefit of doubt. Right. So let us go into the facts of the case. On 6/1/1980, actually, the complainant sent the deceased Rajay Kumar to go to one Rajesh Kumar. He is accused. The deceased Rajay Kumar was sent to Rajesh Kumar, who was given 700 rupees by the complainant to fetch diesel, since Rajesh Kumar said that he has got diesel coupons. At that time, there was scarcity of diesel. సో మీకు చీరాల ఆయన కేసు చెప్పాను, పెట్రోల్ బంక్ ఆయన హరిప్రసాదరావు, వావిళ్ళ ఇంటి పేరు వి హరిప్రసాదరావు, ఆయన కేసు చెప్పాను. ఆ కాలంలో కూడా ఇలాగ కూపన్స్ మీద ప్రభుత్వ అధికారులకి వాళ్ళకి డ్రైవర్లు కూపన్లు ఇస్తేనే పెట్రోల్ కొట్టేవాళ్ళు, అయితే లేదు అప్పుడు స్కేర్సిటీ వచ్చింది, ఏదో చైనా వార్ ఏదో మొత్తానికి గుర్తులేదు. అలాగా ఇక్కడ కూడా 1980లో ఆ ప్రాబ్లం ఉందో తెలియదు అలా యూపీలో. సో ఇతను ఏం చెప్పాడంటే, నా దగ్గర కూపన్స్ ఉన్నాయన్నాడు. ఇతను డబ్బులు ఇచ్చి, అబ్బాయి నాకు డీజిల్ తెచ్చిపెట్టమన్నాడు. రాజేష్ వెళ్ళాడు, తేలా, వాడి కోసం అజయ్ని పంపించాడు. వీడు తిరిగి రాలా. సింపుల్గా మీకు అర్థం ఉంటుంది, నాట్ ట్రేస్. On 8/1/80, this man went to the police station and reported about the missing of Ajay Kumar. మొన్ననంగా వెళ్ళాడు, ఇంతవరకు రాలేదు అనేటువంటిది. They were given a complaint of missing. It was made a diary entry, and immediately on the next day itself, the Inspector Mr. Tyagi came to know about the presence of the accused at a particular place. So this case has started from the reverse. He received information about the presence of the accused near Meenakshi Talkies Center. He, along with his mediators, went there, arrested him at about 6 p.m. or so. So accused Rajesh was arrested. He has given a clean breast of confession that he murdered Ajay because of the 700 rupees and kept the body in the room of some other person. Rajesh Sukhvir, kept in the room of Sukhvir. And he promised, or he led the police party to the room of Mr. Sukhvir, where they found the dead body wrapped with blood stains. Of course, this is a case of throttling and strangulation. So నోట్లో గొడగుక్కారు, మెడ కేసు లాగారు. Strangling and throttling, strangulation and throttling. Okay, the body was recovered. But the problem is, since it is getting night or evening, getting late hours, they could not hold the inquest. The police held the inquest on 10/1/1980 and sent the body for PM examination. Other formalities are there, so the case was charge sheeted. The trial court convinced with the judge, convinced with the prosecution witnesses, and gave life imprisonment to the accused. Now, High Court also confirmed the same. Luckily, the matters came before the Supreme Court. Now the Supreme Court found the loopholes which were not plugged in by the prosecution. It is the duty of the prosecution to prove the case beyond all reasonable doubt, particularly in murder cases. But what happened here is, first, regarding the motive. Can a person commit the murder for 700 rupees? But the prosecution says at that time 700 rupees was not an ordinary amount. It is equal to at least 7,000 by now. Motive, they got a doubt. After all, for the amount, will they commit the murder? That too, the amount is given by the complainant. Ajay only went to ask for the diesel. Motive is very weak. The circumstantial evidence. There are material contradictions in the circumstantial evidence. And as regards the confession, a funny thing is happened. The police were led by Rajesh to the house of Sukhvir, who was later arrested. Total 3 accused are there in this case. And the door was, when the IO just pressed the door, it was open. That means the door was not locked. It gives another suspicion. Suppose when the body is there inside the bedroom, then will you keep quiet? Will you keep it open or will you keep it not locked? Definitely they will take precautions. They would have locked it. They did not lock it. And not conducting of the inquest at the night is another lacuna. Because when it is the next day, definitely there will be some material adding and padding. So basing on three lacunae, Honorable Supreme Court of India held that evidence of last seen theory is inconsistent and not in close proximity of the scene of offence. Inquest postponed for the next day, and prosecution failed to prove the guilt of the accused. The conviction is set aside. Good case law, useful for the accused persons. Please read the case law and enrich your legal knowledge. Thank you.